What is the statute of limitations in probate litigation? In probate litigation, the statute of limitations dictates how much time you have to file your dispute in court. And it can vary depending on whatever the claim or issue is. Factors such as state law, the type of claim, when the issue is discovered, can all influence the timeline. For example, you may have a set amount of time to contest a will or trust or to raise a breach of fiduciary duty claim. Missing this deadline could limit or even completely prohibit you from pursuing your claim in court. It is crucial to act quickly to ensure that your concerns are addressed within the statute of limitations. A probate litigation attorney can help guide you through the various deadlines that might apply to your case. Why does the statute of limitation matter? The statute of limitations is important for ensuring fairness and closure in probate proceedings. By setting clear time limits, they help ensure that interested parties, such as heirs and beneficiaries, have the opportunity to raise valid concerns before the probate process moves forward toward completion. Without these deadlines, the administration of an estate could face unnecessary delays or disruptions, or simply never end. Statutes of limitation can help in the following ways. They can help ensure that disputes are addressed in a timely manner. They can help preserve the integrity of evidence, for example, preventing witnesses from failing memories or documents from being destroyed. Lastly, they can help beneficiaries, heirs, and other interested parties understand when they need to act to protect their interests. What factors affect the statute of limitations? The statute of limitations in probate cases can be influenced by several factors, including state-specific laws. Each state has its own set of rules regarding when a claim must be filed. Understanding these local laws is essential to understanding the applicable statute of limitations. The type of claim. The statute of limitations can differ depending on the nature of the dispute, the nature of the claim you're making. For instance, the deadline for contesting a will might differ from the time limit for raising a breach of fiduciary duty claim. You have to look specifically at each claim and what its statute is. Discovery of harm. In some cases, the statute of limitations isn't going to begin until the harm is discovered, like in fraud, theft, concealment, rather than when the event actually occurred. This is particularly relevant where cases are ongoing and the wrongdoing is concealed. What factors affect common types of probate litigation in California and their associated statutes of limitations? Will contests. You'll typically have 120 days from the date the will is admitted to probate to contest it. Trust disputes. You have 120 days from the date that the trustee mails you a notification by trustee under 1606.1.7 of the Probate Code to beneficiaries, which initiates the trust administration process, to file your claim with the court. Breach of fiduciary duty claims. The statute of limitations for breach of fiduciary duty is generally 4 years from the date the breach is discovered. Accounting issues. The statutory deadline to request an accounting is usually 1 year from the date the executor or trustee submits the accounting. However, this may be shortened to 180 days if the trustee provides a written notice about that shortened time frame on the accounting that they provide you. A beneficiary can request an accounting, which must be provided within 60 days. In some cases, the statute can be as long as 3 years. Consulting with a probate litigation attorney can help clear these things up. Keep in mind that these deadlines can be affected by other factors, such as the discovery of fraud or the actions of a fiduciary like an executor. So it's important to consult with an experienced probate litigation attorney. What are some common types of probate litigation in Texas and its respective statutes of limitations? Will contests. In Texas, you generally have 2 years from the date a will is admitted to probate to contest it. However, it's advisable to contest the will even before it's ever admitted to probate. Trust dispute. You have 4 years from the date you discover or should have discovered the grounds for your trust contest. Breach of fiduciary duty claims. In Texas, again, you have 4 years from the date the breach of fiduciary duty was discovered or should have been discovered to file your claim. Accounting issues. Texas does not have a specific deadline for compelling the accounting of a trust or estate. The deadline is going to depend on whether the trust or estate is still open and whether a court has already approved the accounting that you're contesting. Consider that these deadlines may be affected by other factors, such as the discovery of fraud, concealment, or the actions of a personal representative or fiduciary. So it's important to consult with an experienced probate litigation attorney who can walk through the specific circumstances of your case. Are there any exceptions to the statute of limitations? In some cases, the statute of limitations can be extended, paused, or shortened. These exceptions include fraud. If fraudulent activity, concealment, has occurred, the statute of limitations may be delayed until the fraud is discovered. Mental incapacity. If the person pursuing the claim is mentally incapacitated for any period of time, the statute of limitations may be extended until they regain the ability to file a claim or for some period while they were unable to file a claim. Minors. If the claimant is a minor under the age of 18, the statute of limitations may be tolled until they reach adulthood. Uninformed beneficiaries. If beneficiaries aren't informed about the probate process, they didn't get notice, then they might have additional time to raise concerns. We often see this in cases where a beneficiary or an heir didn't get notice of a probate proceeding and they come back years, sometimes decades later. What are the consequences of missing the statute of limitations and not filing on time? If you miss the statute of limitations, you could forfeit your right to dispute the will, the trust, or take issue with any of the fiduciary actions. The consequences could include distribution of assets that do not reflect your expectations or what you were hoping to come out of that process, a probate process that proceeds with an invalid will or other invalid document, and the inability to address concerns after the estate has already been distributed. How can you ensure you meet the statute of limitations? It's important to file your claim with the court within the time period. Simply intending to file or contacting a lawyer or complaining isn't enough. You have to formally file the lawsuit with the court before the deadline expires. To ensure you meet this deadline, you have to act as quickly as possible. Anytime you suspect an issue, you need to raise your concern and get it filed. In many cases, contesting a will before it's even admitted to probate may give you more favorable legal standing, and you should consult a probate attorney who can help you understand when the statute of limitations starts, how long you have, and what you need to do to navigate the legal process. Understanding the statute of limitations is crucial for anyone involved in probate litigation. Whether you're contesting a will, disputing a trust, or raising a breach of fiduciary duty claim, you must act within the prescribed deadlines. Contacting a probate litigation attorney early will help you navigate the complexities of these time-sensitive matters to make sure you're able to protect your rights. Here at RMO, we protect people like you every day. Contact us today to see how we might be able to help.